Welcome viewers, as per a report by the Age Times on Tuesday, September 19, 2023, the U.S. High Court is on the cusp of concluding whether previous President Donald Trump can take part in later races. This high-stakes choice depends on the translation of the 14th Amendment and comes because of a claim recorded by far GOP official competitor, John Castro. As we proceed with this video, please take out a minute of your precious time to click the subscribe button and the notification bell for more updates from us. On account of John Castro v. Donald Trump, Mr. Castro, a Texas lawyer running for president, fights that Trump's contribution in the January 6, 2021 legislative hull break warrants his preclusion on the grounds of rebellion against the U.S. government. The country's most elevated court has set a cutoff of October 9 to deliver a choice for this situation, infusing a demeanor of expectation and tension into the political field. As this fight in court unfurls, it can possibly reshape the American political scene. John Castro's daring move to challenge Donald Trump's qualification for future decisions has caught the country's consideration. In his claim, Castro contends that Trump's activities encompassing the occasions of January 6, 2021, are adequate justification for his exclusion from serving in a position of authority, including the administration. As indicated by Castro, Trump's direct added up to a rebellion against the U.S., delivering him ill-suited for public help. Mr. Castro, a conservative, declared that the presence of President Trump on the New Hampshire voting form would make it more challenging for him to get little-dollar gift support. As indicated by Government Political Decision Commission records, he gave $20 million to his own official mission while raising nothing. At the core of this case lies the translation of the 14th Amendment, especially Segment 3, which specifies that no individual will hold office, assuming they have taken part in uprising or defiance to the U.S. This arrangement, initially created to keep previous Confederates from holding office after the nationwide conflict, has rarely been conjured in contemporary times. Lawful researchers and specialists wind up partitioned over the utilization of the 14th Amendment for this situation. Some state that Trump's provocative way of talking and activities ahead of the pack up to the January 6, 2021 occasions for sure meet the limit for revolt, while others contend that his activities may not meet the lawful rules for preclusion. Since the 14th Amendment was confirmed after the nationwide conflict, resigned Harvard regulation teacher Alan Dershowitz has long fought that endeavors to discourage the previous president on those grounds are muddled. Recently, conservative David Scanlon, filling in as the Secretary of State in New Hampshire, communicated his position that he misses the mark on power under the 14th Amendment to deliver the previous president ineligible. During a new press instructions, he declared, "Our state resolutions don't give the Secretary of Express any scope with regards to assessing qualification matters." An official competitor's name will be remembered for the polling form in the event that they present their documentation inside the assigned recording period and satisfy the compulsory expense prerequisites. Michigan's Secretary of State Jocelyn Benson began, "Whether Trump is qualified to run for president again is a choice not really for secretaries of state, but rather for the courts." As per ABC News, Gabriel Real, a Georgia decisions official who upheld President Trump, courts will most likely throw out such cases on the grounds that the previous president hasn't been seen as blameworthy. The U.S. High Court's choice to take up this case shows its importance and the potential repercussions it holds for the country. The decision won't just decide Donald Trump's political future, yet could likewise lay out a legitimate point of reference that shapes future cases, including the qualification of up-and-comers in view of their past activities. The American public is forcefully separated over this, with intense contentions on the two sides. Allies of John Castro keep up with that responsibility for those associated with the state house break is fundamental to maintain law and order and defend majority rule standards. They battle that allowing Trump to campaign for office once more would start a risky trend and sabotage the groundworks of a vote-based system. On the other hand, Trump's allies see this claim as a politically persuaded attack on their lean toward up-and-comer. They set that the claim is an endeavor to deny Trump's allies a voice in the discretionary cycle and that it comprises a maltreatment of the overall set of laws for political addition. As the High Court ponders over this case, the country watches anxiously. The choice, expected toward the beginning of October, will without a doubt significantly affect the direction of American legislative issues. No matter what the result, John Castro v. Donald Trump has turned into an essential second in the continuous exchange encompassing responsibility, a vote-based system, and law and order in the U.S. The ramifications of this choice are bound to resound long after the hammer falls in the most noteworthy court in the land. What is your take on this video? Please kindly drop your feedback and thanks for watching.